solicitor. You have to sit there. You're not part of it. Yeah, you're not part of that report. But all I'm doing, I'm not saying you don't. All I'm doing is telling you what happened. So that's all. And if I don't tell you, you can have a go at me for not telling me. Without doing my job. Okay? Thanks very much. Right. Mr. Jolly, it's time to come in. No, Mr. Elliot, I know. You need to come in. Two sit on the table. Good afternoon. Is it okay to speak? Mr. Elliot, or Levin, Treason. Good afternoon, Mr. Elliot. Good afternoon. Yes. Has someone got the dependency, please? Right. Please, unless you want to stand by to address me in the
No, I'm fine.
Alright, so I'm just assistant officer on hearing this application today. Quite a lot of people in court, as you're right, as you're allowed to do. But in the court of law, I do not expect to hear any noise, interruption or any distraction, and if I do hear any such behaviour, I will forthwith all the objections anybody else for. Is that understood? Alright, now then let's Miss Elliot, you're the agent for Levin. And are you Mr. or Dr. Spy?
I'm the doctor.
Wonderful. Now, you're not legally qualified.
I'm not qualified in...
You're not legally qualified. Are you a solicitor?
Not legally qualified, no.
All right. Well, the situation is that somebody who wishes to speak on behalf of your client or friend. Duties are only permitted to be addressed in certain situations by people with legal qualifications, those with the right of audience. Other than that, people are allowed to come to court as a support for people, because we appreciate that the court is a stressful environment and difficult, and often people can't afford legal representation. But in order to keep things in the way that they should be, and there to be decorum and rules, and Mackenzie does not have to make submissions on behalf of the person. You're not allowed to speak for him. All right, you're allowed to advise him and help him in relation to what he should be saying, but what you're not permitted to do as a Mackenzie friend, because you're not instructed as a solicitor.
I'm not party to these proceedings.
Right, well, you don't appear as a party to those proceedings at the moment.
And I represent myself in person.
All right. Let me finish with what I was saying first of all. So if you are seeking to represent the gentleman who sits next to you, you won't be able to do that other than in the terms of a Mackenzie friend. Is that clear?
I'm here as a human being. I represent myself.
I'm quite aware that you're here as a human being. I can see that. Any attempt at facetiousness will not be tolerated either. All right? I can see perfectly well that you're quite eloquent and seemingly intelligent man. What you are not going to be able to do is actually solicitor.
I'm not. I'm not.
Well, we're in agreement then, aren't we? Just sit down one minute, please. All right.
I'm standing under common law.
All right. Stand or sit as you please. But don't stress it at the moment. I'm now addressing Mr. Elliot. Mr. Elliot, who in this particular case has been brought against persons unknown? How many defendants do we have?
Unsure, I'm afraid.
Is this gentleman one of them?
Not that I'm aware of, no, I've not seen him myself, no.
Are you...
Is he resident of the property? That's the main question.
Well, yes, that's okay. Are you resident of the property?
I reside at the property.
Yes. He is a I'll move you to that. All right. Right, Mr. Elliott, there is one problem with your case. There is no claim form. No, this is an application for an interim possession order. There's a claim form and written evidence in support. Has it been served?
Yes, it has, yes.
All right, is there a certificate of service or a
Yes,
service
it's in my witness statement as well, I think we've got a
All right, that's
of
what I don't have. Let's have a look statement, please. Thank you. Thank you. All right. Well, I'm satisfied that services has been enforced appropriately, so there's written evidence, so therefore you are compliant with CPR in relation to this. The situation is that I have to determine a case in relation to the law just before the application is for an interim possession order. Person can make a claim for an interim possession order if they have a right to possession of premises and have had that right throughout the period of alleged unlawful occupation. And the claim is made within 28 days of the date on which the claimant first knew or reasoning to have known the defendant or any of them were in occupation. The evidence clearly is that very quickly after being made aware that you were in occupation of the property, they made their application, so they satisfy those criteria. Alright. I cannot give them an interim possession order if you or any of the other people enter or remain on property with the consent of the person who owns it. So do you have the consent of the person who owns that property?
We do, Your Honour.
You're saying that, what's the name again, Mr. Nevins, who owns, you agree that Mr. Nevins owns the chapel?
No, I do not agree with that.
Well, Mr. Nevins is the owner, is he not?
Yeah. He claims to be the owner, Your Honour.
And who do you claim to be the owner?
The people.
What people?
The general population. It's public. It's public property.
On the land registry, the owner is put down as the property belongs to the public. You've done a land registry search. You have that evidence before you?
I don't have a land registry.
No.
We're in lawful occupation under Article 61 of the Magna Carta.
Alright. You got a copy of Article 61 of the Magna Carta. Are you pleading any elements of the European Convention on Human Rights or just the Magna Carta?
Just the Magna Carta.
Alright. Do you have a copy of that article?
I've got a book with it in.
Have you seen it?
No, I haven't. Nothing's been served and anything that's been today.
We've not been... Sorry.
You haven't been served with it?
No.
Anything else? Oh, can I please have a look at this article to which you refer?
Article 61, lawful rebellion.
This is the lawful rebellion section.
That's correct, Your Honour.
How does one define a baron?
A baron?
The barons have choose 25 barons of the kingdom. How do you run barons?
I don't have a copy of Black's Law Dictionary here with me, Your Honour.
You're trying to stick to uphold the law, you're trying to stick with the definition.
I thought, as I'm not legally trained, I thought Your Honour would be in a bit better position to...
Your defence that you have lawful occupation under section 61 of the Magna Carta, which refers to barons.
That's correct, we're barons acting in lawful rebellion. Could I take your name, please?
My name is Deputy District Judge Nassau.
How do you spell that?
N-A-S-S-A-R.
Can I ask what law we are administering in this court today?
Civil law.
Civil law. Are we administering the law of the land?
We're administering the civil law according to the civil procedure rules, and I'm going to be guided in currently performing the application of interim possession order. There are defences to an interim possession order, one of which you have raised. The defence that you have raised is that you have the consent of the person to occupy the property. And if I am satisfied on ballot, on the evidence before me, that you have consent from the person, I can't make an interim possession order. Alright? The evidence that is before me as to whether or not you have consent from the claimant, or consent from a person who at the time consent was given had an immediate right to possession of premises. If I am not satisfied on the evidence before me that you have consent of a person who at the time when consent was given had an immediate right to possession of those premises, then I move to make an interim possession order. So it's important that I consider what you raise your defence to be. The only defence at the moment available, and it's Civil Procedure Rules, section 55.21. Alright, and the evidence that I have before me is that Mr. Nevins is the owner of the property as registered on the land registry. It's going to be very difficult for you to shift that evidence that you say in the lack of any other evidence, if you like. Because what you're seeking to persuade me is that the property is not private property. There is no private ownership thereof, and it's owned by the general people. I understand your argument, and that as the general people own it, they've given their consent.
That is correct, Your Honour.
I'm not saying that I agree with you, I am just ensuring in a summary form that you comprehend, that I comprehend what it is you're raising. The Magna Carta has formed part of English law, but the procedure rules supersede that. Furthermore, if you were going to refer to something like the Master of European Convention for Human Rights, which we have endorsed in this section, it might have had more sway.
With all due respect, Your Honour, the Magna Carta overrules the Union on Human Rights.
I disagree.
The signing of the treaty to take us into Europe was an act of treason because it breached the Magna Carta.
But we don't need to get into a very interesting discussion at this point. I need to apply the law to the facts. And that's what I'm proposing to do.
I'm standing under common law, Your Honour.
I'm aware I'm standing under common law, you've told me twice.
That supersedes any statute.
You can stand or sit in my court, that I do not mind. With me in a verbal battle about the Magna Carta and the European Convention on Human Rights is not going to help you, trust me.
This is public property, Your Honour. These are people these are gravestones put there by people, paid for by people. The building itself was paid for by people. I've got a breakdown of the payments for the original chapel. And this details bricks, mortar and monies paid for by individuals. That building was put into trust for the people, Your Honour, and at some stage it has been unlawfully ownership.
It stands as a matter of law though at the moment, doesn't it, that that property is in private ownership, lawful legal private ownership.
Yes, it has.
And so as a matter of law at the moment, the only person who can give consent to these people to do that, as a matter of law,
As a matter of statute, Your Honour.
is the person who do it.
Can I ask what the law of the land is?
Well, the law, the definition of owner is what we need to be concerned with, or the person who owns the premises. And if you're seeking to suggest that actual transfer of ownership is something that in itself is unlawful, the way to unravel such a thing is not just to take occupation in there, but it's for the court to determine that interesting argument at a later date.
We're occupying... carry on, Your Honour.
I have now to ask myself the following questions. Do you or do you not have consent from the owner of Platt Chapel in the definition of the interpretation the kind of corporate owner, which is the lawful legal owner, as registered in the land registry? You do not have this permission, do you?
We have permission from
Yes.
the owner, that is the people.
No.
And we further...
Right.
We have
Let me ask you this question, it's a very simple yes or no question. Do you have permission from Mr. Nevins to occupy that country? Do you have permission from Mr. Nevins?
No, I do not have any written permission from Mr. Nevins.
No. In my view, it is incontrovertible, and I find on the balance of probabilities that on the evidence I have before me, at this point in time, for the purpose of the interim possession order, Mr. Nevins is the only person who has immediate right to possession of the property.
I would believe that's incorrect.
Well, that is...
We are
Unfortunately,
acting under Article 61 of the Magna Carta.
Yes. Well, my interpretation of the Magna Carta doesn't assist you in terms of
Would you just like to...
I am going to interpret this case and determine this case in relation to the Civil Procedure Rules, section 55.21.
Okay, can I bring points up on the CPR?
Yes.
Okay, we've not been served with most of the documents required. We've only been served...
So that you're just reading something else this is written to you.
No, this is a form.
Why don't you just take a moment? You're now saying you've not had service documents. Am I speaking to anybody at all? I'm not, am I? It's continued over, is it not?
Is there another document to that?
Or does it just go to you?
It was just that part. So that's the other two sections of that, Your Honour. Didn't you hand yours in? Oh, okay.
We'll have a copy taken for you. Right, well, service of the required documents has taken place according to the CPR. There is a witness statement and proof of service. So in relation to your argument about lack of service, I don't oppose that argument because I've already shown at the start of the hearing on questioning. I had the witness statement which proves, just so you say it proves service. Your point, which may or may not be valid, but have we not determined it, is in the form of owner. He doesn't say when he has a right to a property with no evidence. So, with information required, I'm satisfied on the sworn evidence that I have before he is the owner. For the purposes of the court, he who has the right to occupy, he who has the right to immediate possession, he who has bought it and has registered his interest in it according to the land registry, it's a matter of Bulletin 1. I am then look to see section 55.22 as to when I should and should not give grant an interim professional. Right? And that is specifically Rule 55.25 of TBR. Right? So, deciding on the responsibility for professional orders, the court will have regard to whether the claimant has given or is prepared to give the following undertakings in support of his application. And this I come to you. It's very important that you are prepared to give such undertakings, or I cannot grant an interim professional order. If the court subsequently orders uphold this gentleman's argument in relation to the Magna Carta and in relation to lawful rebellion, and if Mr. Nevins cannot prove the fact, or I am wrong in considering this for evidence of sufficient to prove his ownership, do you undertake to reinstate the defendant if the court orders you to do so?
If the question is just down to the ownership, it would take 5 minutes to get full copies of land registry.
No, the court. I'm considering whether to grant an interim possession order. I can't grant one. Interim means in the interim.
I understand.
Because obviously this is in a block list, and a court is going to need some considerable time to determine the final outcome. I can't give an interim possession order unless at the final hearing the court orders them to be reinstated in the property. Will you comply with that?
Yes, we will.
All right, and you are not, or your client is not, permitted to damage the premises in the meantime.
No.
You're not permitted to grant a right of possession or occupation to any other people.
Understandable.
Not entitled to damage or dispose of the defendant's property.
Yes, I understand.
Now, I have to consider whether the conditions set out in 55.2.1 are satisfied and whether the undertakings are adequate. If you find that the undertakings are adequate, those are the matters which you must undertake to do.
I understand, yes.
Perfectly simple, really. I will make an IPO into a possession order. This is the wording of the CPR. So there are some, and I say that because there are some applications that come before the court where the court has discretion.
Can I make further submissions?
No, I'm just going to go through this, and then what I'm asking one of you to do is to make notes out of what I'm saying, because I'm being guided by the CPR. Claim to file a certificate of service of the documents or proof of service to the satisfaction of the court. I find the proof of service to the satisfaction of the court, therefore 55.252B is satisfied. 282 is satisfied. B, I consider the conditions set out 55.2.1 is satisfied, which is that the lawful right, as in the law, as it stands at the moment, and there's an assumption, which I'm prepared to make, that the lawful legal owner, as with the land registry, is that person who owns it and has the immediate right to possession and has had that right. And that your undertakings are adequate. Alright? Now, the interim possession order is going to be in the form set out in Practice Directive by matter, and it will require you to vacate the premises within 24 hours. Then the court will set a date for the hearing not less than 7 days' time.
Can I make further submissions before you give your ruling? Given that you're not accepting that common law rides above the statute law, which I believe is true in law, I'd like to make some submissions under the ECHR.
Alright.
Under the ECHR, Article 6, We have a right to a fair trial.
Yes?
Under Article...
Let's put them up.
Sorry?
So you're raising Article 6 that I've breached your right to fair trial?
That's correct.
All right. Let me tell you what... Excuse me. You're distracting me by walking across the court. Article 6 of the Convention of Human Rights quite rightly refers to Article 6, the right to a fair trial. What that means is that you have the right to defend yourself, you have the right to see the evidence against you, you have the right to make representations and to be heard fairly, you have the right to seek representation if you so wish. All of those rights have been satisfied in your regard, so in no way has this hearing breached your Article 6 right of the European Convention of Human Rights.
Article 8.
Family life.
Yes.
Yes.
By granting an interim injunction, you're depriving of the right for somebody to live.
Well, the right to family life under Article 8 it is just that. It's family and private life, and it has to be a disproportionate interference with that.
There is a tornado tonight, Your Honour. If people are forced to go out from a protected environment where they've claimed sanctuary in a church...
you didn't raise it as sanctuary a moment ago. You were lawfully rebelling.
Well, Your Honour just rejected the you rejected the rule of common law.
I'm not rejected the rule of common law. I'm upholding the CPR rules of law before.
Article 8,
let's deal with Article 8. I'm not reviewing Article 6. Article 8, the right to family and private life. I would only be breaching Article 8 by making an interim possession order. If that was a disproportionate and unlawful interference with your family and private life, what the High Court has determined in relation to unlawful interference with family life is this, that if the body for who is making that decision, in this case that's myself, has a lawful justification to do so or is able to do so in law, that does not disproportionately breach your Article 8 rights to private life. The fact that there may or may not be a tornado, we don't know because the weather is not always accurate. It is not a factor. This would be more of an act of God, and it's not a factor for me under the CPR to determine whether or not that's a circumstance under which I cannot give you.
I'd also like to claim that Section 10 is enabled.
Section 10?
And 11.
And for those?
Like to gather and express oneself.
Yes, but not wherever you feel like. Those relate to protesters and marches. You can go and gather wherever you like, just not in this chapel to which you have no right.
This is a chapel for the homeless. And that is what is being protested. There are banners outside saying that that there is a protest against the homeless. This was built in 1700 for the homeless. On the church.
Is it shop for homeless?
It's not a shop for the homeless. It's a commercial purposes, and I would now protest the evidence to prove that there are commercial enterprises from the building.
Presumably, if there's a chapel for the homeless, there must be registered such a thing as charity. Various things. How long have there been chapels for homeless? You say since 1700?
Since 1700.
You say that nobody else has used it for any other purpose?
I believe unlawful purposes. It's sanctuary ground, and we also claim sanctuary.
All right. Well, unfortunately, it seems to me that my hands are somewhat tied in this case, because on the evidence before me, I am satisfied to my satisfaction that A, the matter has been served properly, and B, that you do not have the permission of the owner of those places, who I consider to be on the evidence, Mr. Neville.
The owner has also been to the property and disconnected the electric and water, another breach of human rights, and it's illegal. I don't believe he's a qualified electrician, unless my friend can confirm that he is a qualified electrician.
Whether or not that interference with the electricity and the other water don't constitute interference with your human rights either.
The human right is a water. Water is a human right.
No, people pay for their water.
It is a human right.
You haven't got the right to be there, I'm afraid.
We do have the right.
I know that that's what you think, but I'm here to determine whether, in my view, you do or you don't.
We've claimed that building under Section 61 of the Magna Carta.
I know you have, and I'm making an interim possession order against
Any attempt to evict us from that property would be treason.
I'm going to make an interim possession order, as I am entitled to do on the evidence, under section 55.21 against you, which will mean that you are to vacate the premises within 24 hours of the first of the order, which is today. And then a date for the next hearing of the claim to possession is going to be made not late after the date on which interim possession order is made. Alright. So, that is my finding.
We've been running from the church that we built for the homeless. We've been keeping homeless people. We have got evidence of that. Unfortunately, we didn't really have much of a time to prepare a proper defence here, which is why we claimed that. Obviously, I don't have a little bit of part of obviously people that have got involved later on, but we've been running kitchen there for people. We've been around the local area, taking donations and sleeping bags for one clothes, and then handing it out to the local area. People have been noticing a difference. Now, that chapel has been left unused for a long time now, and it's not going to get used for anything else really. From what I can tell, the rent asking price means it's essentially unusable as a commercial property. However, at the moment we're using it as a really good space to do a lot of good in the community. I think in terms of right to possession, as he says, it was put in trust by people, and at some point it's been, obviously whatever the law stands now, I mean, well, it's not the law, is it? That's a legality that's happened. If he owns it now under
The law.
The land registry.
the land registry, yeah, but the law originally stated that that was for people in Leicester, and that was under a contract. Now that was a breach. It's
Well, that doesn't matter. As I say, I understand your argument completely. I'm not without understanding, and I'm most certainly also not without empathy and, you know, commending you for what you're doing. Not all just sitting there getting smoking drugs and being annoying to the community. You're doing something that's contributing. Unfortunately, as a judge, and not just today, it happens on many days, I have to make decisions that perhaps don't sit quite right with one's heart, maybe, and one has to put out sympathy out of one's mind, and I have to look at the black and white law, and if I'm told this, 1, 2, 3, 4 things, then you have to go to 5, I have to follow the law. And so those things are peripheral to the issue. It's not to say we don't consider them, but the situation, in my judgment at this moment in time, is that sufficient criteria has been satisfied to satisfy me that it is right and just, with the overriding objective in mind, to make an interim possession order. The matter will come back very shortly for a longer hearing, when all of these matters will be raised.
More of a question on me, but I mean, if obviously that was put under contract of trust from the people who built it, and it was eventually unlawfully sold to someone, how can anybody lawfully own it now?
Well, that's an argument you will have to raise, but I mean, I can't give advice. Lawyers will have specialities in contract law, and it may very well be that it'll be deemed accepted contracts over a period of time, for example, after X amount of transactions have gone on, that then becomes, as due to conduct, something that's lawful. It may well not, but for the purposes of this hearing, the evidence that I have before me, I'm not saying that you don't have an argument that should be raised at a later stage. You clearly fundamentally believe in your right to be there. My criteria, my job is to look what has been served, has the CPR been satisfied, and is it right and just and appropriate to make interim possession order. It doesn't seem to me that I can do anything other than make interim possession order at this moment in time, given that the evidence that I have is that this man owns it. It's not disputed whether he owns it. It's not disputed, but what is trying to be disputed is that he shouldn't be that because of very old law, and sometimes very old law works. It's not always the case that just because it's old it doesn't work. And takes precedent.
So just call it the ECHR as a statute, yes? It's an Act of Parliament.
The European Convention of Human Rights Convention.
So not ECHR, the CPR.
The CPR, criminal procedure rules.
Yes.
Those are the rules which I apply in the civil court.
Okay, those are an Act of Parliament, yes?
They are.
Okay? The law of the land in this country is common law. It's mentioned in the Magna Carta of 1215. Common law trumps statute law.
All right. Well, that's a so what you're saying is that I can't be bound by the criminal procedure.
You shouldn't be bound by it. We're claiming Article 61 of the Magna Carta, which takes precedent over all statutes.
I'm not with you on that. In my view, I think it's perfectly right for me at this point in time to be bound by the criminal procedure law. And that is my decision. So the interim professional, you need to vacate the premises. And that's order. I'll draw that up now, and that can be served.
I would point out that going against Article 61 of the Magna Carta is an act of treason.
That's the matter that I will have to deal with. My job today, as a member of the judiciary and Mr. Judge, to look at the evidence before me, look at the application, and make a decision. Not all days at work are easy, but that's my job. I'm satisfied, with the lawful owner, and I'm satisfied you don't have the consent to be there. I'm satisfied they serve the documents correctly, and on that basis I'm making an interim professional. So that will be brought back to court at a later date, and in the meantime, there are undertakings that the premises won't be damaged. No one else will be allowed to live there. The place will be kept, so the matter can be heard as long as this was an interim possessional application and a short period of time allowed for it. All right, I thank you all for coming to court. I shall hand you back your statutes and that's all the application. This is an application cost. No. No. All right. I'll ask you to vacate court for a short while whilst I draw up the order. Go to order.
No.
Well,
Well, they've got to come up with a full hearing. They've got to go
we've not seen the evidence for today that they've got, because we've not received any of the evidence.
That was-
No, I mean, actually, that's just a notice to the house. We've not seen any evidence from them to the owners of the building or anything.